Okay, good morning and welcome to Mo Knows featuring me, Monica Mo Justice. I gotta check that sound button. Let me just check the sound. Okay, so we on and popping this morning. Good morning, Carla. Good morning, still Cross. The Cross family. Okay, this was a doozy of a doozy. I had to get some beauty rest on this one. I was gonna come live last night and talk about it, but I felt like I needed to watch. The pulse of the people. Um, Great, thank you, Carla. So, um, I am a member of the Black community. I don't know what community people believe I belong to or whatever. But nevertheless, I checked the pulse of my community at large, and there was no surprise here for many what the verdict was. Not guilty. But I was surprised at the outrage for the not guilty verdict. All right, so let's just go into beginners. Everyone is innocent until proven guilty, and the burden of proof in a criminal case is on the prosecutor. Now, what was interesting about this case was that the prosecutor had a heavier burden, because you would think that all the evidence was there. There was film, there was footage, there was videos from every aspect you can get a video from, so you can get all kinds of perspective on something, on the situation. But it depends on the perspective of the person telling the story. I wasn't surprised when evidence cleared him. Good way of putting it. Let me just talk about this burden of proof, that this burden that the prosecutor has. Their burden, once a person puts in an affirmative defense, which in this case was self-defense, and we're going to see this type of defense played out in the Ahmaud Arbery case. So brace yourself, because self-defense goes back to who now becomes the victim. This is why in the Trayvon Martin case, you had the son of a judge walk away, because self-defense becomes a question of who was the aggressor. And what it became for this prosecuting team, who were not they were not the best prosecutors that we've seen in a long time. They remind me of probably the prosecutors that went up against O.J. Simpson's team. And all the odds was against Carl Rittenhouse's team. He didn't have a dream team in place. People were not confident in their ability to defend him. So these guys just didn't do a great job presenting evidence or presenting their evidence in a way that proved beyond a reasonable doubt that it was not self-defense. And that's what it boiled down to. Hard case to really prove. When they came back, as I said yesterday, with a question on the other dude that lived, the surviving person, I always, after I heard the testimony, because never once did I hear in the media, and now there's two kinds of media on trial these days: social media and Main Street media. So now we who turned we being like influencers or people that are able to tell their own stories and give you play-by-play accounts and stuff, we are now one of the most hated entities out here as equivalent to mainstream media, news media. They now shun social media for its misinformation as it relates to the events of the day. Film footage, even expert witnesses showed it was self-defense. I would not say that, because the law says that you can defend yourself, right? But it has to be equal. It has to be equal defense. So when the situation with Gross Courts, just because Gross Courts had a gun, it was equal to equal, gun to gun. Maybe not big gun to little gun, but you can say self-defense there because he had a gun, and he had a gun. The only thing that happened with Gross Courts is that he froze. And you can't defend yourself or arm yourself with the gun and then be afraid to use your own weapon. And that's basically what happened with him. The other dudes, it was not clear during testimony that the prosecutor was setting up Rittenhouse to be an active shooter. I could not find any testimony that led me to that. So then the only thing that would lead you to that is their closing argument. And the closing argument presents him as an active shooter. And that's what gave me some pause to the end, because I was like, damn, I wasn't looking at him as an active shooter, as what did the crowd think he was? Because even with their one witness that they put on Gross Courts didn't give me the impression that this dude was an active shooter and that's why he was pursuing him and that he had a right to pursue him with a gun. What about the stomp to the head and skateboard to the head while Rittenhouse was on the floor? Okay. This is directly answering your question still. If you were looking at this from a perspective that these people don't know what happened when Kyle shot the first guy, Rosenbaum, when he shot him. Is that the dude's name? I don't know, I forgot the darn guy's name. I want to say something about this Rosenbaum. I'm gonna come back to that. I just want to say something about this Rosenbaum that seems to be the theme that they're putting on Ahmaud Arbery. Okay, so here Rosenbaum, whatever the dude's name is, he knows that Kyle has a gun and he pursues him he pursues him anyway. So he wasn't afraid that the guy he was going after had a gun. So I guess that's why they saw it self-defense, because if you're stupid enough to go and chase down somebody with a gun and all you got is a plastic bag with a water bottle in it, I guess you deserve to get what you deserve to get. But in the mindset of what we're supposed to believe Rittenhouse mindset was, he's going to grab my gun. He's going to get my gun and take my gun from me. So he's going to take my gun. Silly rabbit, tricks are for kids. If you wasn't out there with a gun, nobody would be taking your gun, silly rabbit. So anyway, so that is one of the biggest issues. And that is what we're facing in the Ahmaud Arbery case also, because one is saying that he had a right to self-defense. And he's saying, even though I was pointing my gun at Ahmaud Arbery, he did not have to approach me. Once he approached me, he became an aggressor and I had a right to defend myself. Even though we chased him down, and see, the testimony that he provided was, my dad and I, we didn't chase him down. Doofus over here with the camera, he chased him down. We watched it from the rear view mirror, like, oh shit, he's dipping, like he's doing all this damage to him. And he says the moment of truth, and what made him scared now that Ahmaud Arbery would do something to him, is because of the, had it not been for the actions of the videographer, he probably wouldn't have been so aggressive towards me and want to grab at the gun. The issue is, and I'm not sure that the DA in that case has proved which happened first, the grabbing of the gun or the gunshot wound, because they're leading us to believe that he was first shot in the stomach and then he lunged and he was doing all that fighting and shit after he was already shot the first time. So the question is, do you have that fight or flight after being ran down and running for several minutes, 5 minutes, to still give that kind of fight if you was already shot one time? But back to Kyle, and the stomp in the head. So if this second group of people that were chasing him, right? You didn't get from the testimony because they didn't bring forward the witnesses to corroborate how these people got into the chase. So you don't know if these were people that were present and saw him shoot a person, or they saw him running and then they heard other people who were back in the area where he shot the person at saying he just shot somebody, reacted to he just shot somebody. What would have been a critical witness for them to have is the guy that kicked him in the head. If they had produced that dude could have told you why he decided to leap over a guy with a gun and kick him in the head, but they couldn't find him. These are people that had drones out here, FBI, all this other stuff. They could not identify the guy who kicked. They could not or did not produce the guy with the yellow pants. So it was a lot of people they didn't produce that they could have produced, that could have made a more compelling story, that it wasn't self-defense and that it was this gang, this white gang that goes, professional protesters that go to protest to protect property. So they just couldn't prove, they just didn't prove that. And that's all the elements I think they would have needed. And then one last important element is that this jury of your peers proposition is something that people keep forgetting. They had a judge who was pro this defendant, obvious. But if you listen to most people tell you stories about judges, they will say judges are more pro the defendant because they don't want it to come back that they didn't give a person a fair trial. So they kind of lean more on them. What else stood out the most? They didn't produce because it would have worked against the every person that they put up there on the stand, their testimony harmed the DA, and their testimony harmed the DA out the gate, because every person that was a witness, guess what else they were? And this is probably why they didn't produce the other people, is because they arrested them for vandalism or other shit, and they couldn't get them to testify point blank. But the other guy, they say he was completely unidentified. The problem they had was that they did not, hey, Ms. G, they did not show, they showed the bias Everyone out there that evening was breaking the curfew. So everyone needed to be charged with breaking the curfew. You cannot bring before a jury, right? And say, hey, listen, this dude right here that's testifying was breaking the law and something bad happened to him. And because something bad happened to him, we did not charge him for breaking the law. That is like having somebody break into a warehouse, climbed in through the roof, right? And he falls to the ground and breaks his legs and cannot break his leg, cannot get out of the place. In the morning time, people arrive and they find him inside there. And you say, okay, we're not going to charge you for breaking and entering because you broke your leg. Nah, boo boo. You got it. So this is crazy. So this is what occurred, in my opinion. And I just want to take a moment to say, welcome to Mo Justice. Mo Justice Land. So the thoughts and opinions here are that of my own, based on my own experiences and my own reasonableness as a person. You're entitled to your own thoughts, and if you make me greatest. Okay, moving on. Just have to throw that in there. Okay. So I don't know where else to say. I mean, you cannot start a case with everybody that's up there, and then you try to make yourself seem so big and bad. Oh, I'm gonna prosecute him. I have a case against him that's being heard in January. So he's testifying here of his free will. No, he's not. You made a deal. It's it makes it look shady. So those are the things. Last but not least, if you have the biggest juror, which is the judge, on your side, and then you hear them, when you hear them speak, they were all residents to Kenosha. So they talk about these people being vagrants and just getting there for the, coming there for the joy of it. What picture did they paint of Kyle? No, he is not from wherever the neighboring county was. He's not from there. His father lives here, but in that gallery, you only saw his mama. But his father lives there. He had his sister's boyfriend was like his best of friends. He helped him purchase the gun. He had a big daddy for that lived there in Kenosha. Why didn't his daddy purchase his gun? So, those are questions that just stood out for me as I was listening to this, and I was like, oh, stuff don't make sense. If it doesn't fit, that's what this jury did. Now, people were like, the composition of the jury is not that of the community at large. Question, whose community are you talking about? That's one of the most important things. Yes, we encourage people to go out and vote, because once you become a voter, one of the privileges of voting, besides getting to vote, the other privilege is you get to be a juror in these trials. If you live in the places where these trials happen. So all of these people converging on the community of Kenosha, I don't agree with it. That's not your community. The people in that community feel a certain kind of way. This is their answer. They're saying, one, stay out of our community, and two, because if you come here, we will shoot you and kill you, and you won't get no justice here because you are trespassing on our lives. Don't bring your social issues to us. We don't want to hear it. We take care of our own. That's what they showed. Um, and I'm not mad at them for it, because I honestly believe that in our own communities, we need to take the same stance. We need to take the same stance. When they put the Edith Bunker looking woman up there and she spoke, she sent chills down my spine as to why I don't go visiting in some neighborhoods. And we got some in New York. I don't go to Bensonhurst, and I will tell you, I do go to Howard Beach, but by day only. In New York, those are just places I don't go. They've known zones that just say we raise our kids a certain way, we believe certain beliefs, and that's just the way it is. It's some places you just can't go. So people are outraged because this is white on white crime. Yeah, these two entities were white gangs. I'm not calling no particular name to it, but they're well-known white gangs converged on a protest with two objectives in mind: professional protesters, and they know each other. They were identifying each other in their videos. It was creepy, but it's okay to have white gangs in America, but it's not okay to have any other ethnicity gang in America and it be allowed. But this is what this trial sends to you. And in their community, they protected their own, and they knew what the stakes were going in. It's hard for us New York City folks that live and are used to living in a yo, cooking. Still. So I have a friend who lives in let me just break out. I have a friend that lives in Texas, who grew up in Texas, who came to live in New York. And all I ever heard was, I can't wait to get back to Texas because this shit right here, not having no guns, walking down the street and stuff like this, it's hard, it's inconceivable, right? But to me, as a New Yorker, it's inconceivable to go to another state where people can do that and do it so openly. And it just, it's a hard adjustment. But let me tell you something. If Momo moves to another state, it will be a state with a gun, because she will definitely go get her a license, because I am taking off the head of whomever when necessary. One thing I will tell you, I will not be afraid to pull my trigger if it's in my hand. People play too many games around here. Your life is too precious to be playing Russian roulette with it. And that's what came out of this. I will reinforce my position that I will not be going to any protests and dealing with any protests. If you see commentary moving forward that talk about the bias of the judge and why the judges should be replaced, that these are Trump judges and so on and so forth. Again, these people are seated in most positions being judges because you, the voter, put them in that seat. So understand the power of your vote when you are choosing to vote or not to vote. Because most of the things that you are angry about are little simple things that you may be able to change. This is a local judge. This is not a lifetime appointment to the position, even though he looks comfortable in it. But again, the people raising the hoopla are not the people that live in that immediate area. At the end of the day, I will never understand, what does vandalism and looting have to do with so-called just cause protests? Here's what I will say about the vandalism and the looting. I didn't understand it. Um, in I didn't understand it in the Rodney King situation, right? But I think I was too young to really process what that meant. Only that we saw a black man get beat down by the police. And then the only thing that I saw to juxtapose against the Rodney King was the truck driver being dragged out of his car, out of that big truck, into the street being beaten. When it hit me that this is not a resolve. Um, People, when they are oppressed, they will tear down everything because they don't want to be oppressed. In this, in the summer of 2020, when we were in the midst of the pandemic, people were oppressed. They were told they must stay in their homes. They have to social distance. There were so many restrictions put on folks that was enough to take to the streets for any purpose whatsoever. Many of their personal liberties they felt had been taken away from them for the pursuit of life. Okay, but some people didn't really understand that their freedoms were being taken away temporarily so that you could live, but they preferred not to have them taken from them at all. So they took to the streets. So any reason, they probably could not care the less that a young man arguing with his girlfriend over child custody or whatever it was, stealing of the coochie, because remember that's what it sounded like to us. He came in there and scooched her coochie, and she was having a ookity fit. And he took, whatever her story is with him, went there one day to claim his son and got into an argument with his baby mama, and she called the cops, and he had an open warrant, and they went to take him down, and he walked away in a fit of anger. He walked away, and those probably the worst steps he ever took, because the other man shot him in the back. Police officer shot him in the back 7 times. No one even paid one iota of a second that was the issue at hand. The issue at hand for the people on this particular day in the Kyle Rittenhouse case was that protesters was coming to the city, and the same police they were angry at could not control or contain the crowds. There was a blatant disregard for the law at hand that said you could not be in the street anymore. And people took to the street. And they took to the street either to wreak havoc or to protect property. Either way, everybody that was on those curves at night was there for some materialistic reason. If it was to destroy the property or to protect the property, they were risking their own lives for property. I don't know if looting in this matter was stealing or what have you, but they were there. The bottom line is 2 people are dead. One person could have lost his freedom for life, and a fourth person could have been dead. And they all did it in the name of property. We need to get our priorities together. That's why I'm gonna continue to live on my merits of, God first, family, and then career. Whatever it takes to just fund me. um are my priorities. But Rittenhouse will there will be more Rittenhouses to come. There's another trial. I'm gonna try to get into it and, and watch it. It has to do with, again, protests. To me, you could tell where the decision was going to, where it was when the judge said, you will not refer those injured as victims. I understand. So when we hear sound bites from anything, we walk away with impression. Like, we walk away with an impression, and we formulate opinions from that impression. So I respect Ms. G's opinion, um, but I disagree with it only because everyone out there that evening was violating the stay at home order. So everyone, including Rittenhouse, was either a vandalizing, looting. They were all considered degenerates because they were not adhering to the law at hand on that evening. So nobody was an innocent bystander. Nobody was a victim because you could have stayed in your home. There was a do not come out at this time order in place. The judge alleges that his his do not call them victims order um, was because working in the mindset of jurors, right? So he's actually saying that jurors are a little stupid. If you're really paying attention to what he's saying, right? He's not dealing with the most literate group of people. That's how I took it. So let me just play it out. So if you tell these people in their heads that uh, Mr. Rosenbaum is a victim of Carl Rittenhouse, you're now taking away the ability for them to come to their own conclusion if he was a victim. You are telling them that he's a victim. In court, they normally refer to every victim as the complainant. I've never heard in the court cases that I've listened to them describe the person who is deceased, the murdered victim, the homicide person, as a victim until the jury comes to a conclusion. So I can't, but maybe other people have, and someone can show me a case wherein they describe somebody who was killed as a victim. They normally try to humanize the people before you. In this case, we had no humanity for any of the deceased because Rosenbaum was described as somebody who either A, came out of jail or just got released out of a mental institution and or was very aggressive and didn't have his medication or could have not taken his medication, who was a pedophile of some sort because some of his previous charges was something to that effect or something to have to do with some domestic violence issues. I've heard other people describe it as some crimes against little boys. So, but I have not. So let me just put it, I have not confirmed his past criminal behavior because I was not interested in it. I was interested in the fact that this other dude was running away and turned and shot him. Just like the DA was trying to convince and make them see an image that was there to be there. That's why the judge got upset and asked if that's the best image they had, trying to mislead. I don't know which image you're referring to. If, Um uh the juror, serving as a juror, you're the determiner of facts. You determine if a person is the victim or not. You are the person, you're the person who gets to determine what's a fact and make it into something. What is unfortunate is I don't know if Anthony Huber or Mr. Rosenbaum were natives to this area, but they damn sure accepted Carl Rittenhouse as a native to their land, and they protected their own in this case. Um, I don't know what image you're talking about. If you're talking about the video footage, the judge was an old judge with old principalities. He needs to get into the 21st century or the 22nd century or 25th century, whatever century is up moving, he needs to get into that. But what the district attorney did not have was experts. And it's surprising to me that they were unable to get, based on the type of case this was, they were unable to get experts. Um, which leads me to believe that experts probably thought this was self-defense. They probably could not add to the case, but could hurt the case on other ways. So they was in a quagmire there. They are trying to determine if there was a bag or a weapon, which was irrelevant, because if someone is running up on you, are you going to see what is first or protect yourself? So Rittenhouse protected himself. He shot him. So what you're saying right there is you're justifying him shooting the person. If somebody is running up on you, is what I believe I'm reading what you said. Somebody's running up on you. And you're running away. And you post up and you shoot the person. They are trying to determine if there was a bag or a weapon. Well, the reason why they needed to know if it was what would be, because you have to, in order to use deadly force against somebody, it has to be the same type of deadly threat. You're not justified in using deadly force against a person who doesn't have the threat has to be equal to each other. And that you could not see in this case. You could not find how it was equal to each other. So now, Mo, if I have to protect my family or home, protecting your home is different than protecting property like a store. So in your home, you have more, there's more leverage to you with your protecting of your property if you lawfully have a right to have a gun. Okay, so just starting there. So if I have to protect my family and home and I have to use deadly force, my lawyer could refer to the People versus Rittenhouse. No, your lawyer cannot refer to the People versus Rittenhouse. You know why? Because Rittenhouse is Wisconsin and what happened up there. Now, if there was some kind of appealable issue and Rittenhouse went to the appeals court and it became a decision on that level, your attorneys may be able to use a decision in the Rittenhouse case if it was similar to an issue that came up in your case, or if it went to like the Supreme Court. That's the only way you can refer to somebody else's case as an issue. the right to bear arms. If your state has in their decree that you have a right to bear arms, you can bear arms. You can protect yourself within the confines of the law that issued you the gun. The kid didn't know what was thrown at him. With tension high, he reacted as such, deadly force to harm to him. Well, basically, what they tried to present was no, he didn't know what was thrown at him, but neither did the prosecution. And that's what's weird here, right? Because the prosecution did not redeem the bag that was thrown, nor the incendiary items that they used to um, put fires out. And these people, Rosenbaum, etc., they were doing activities, they were engaging in vandalism and setting stuff on fire. So it's more than likely they felt like whatever was in the bag was something that can ignite something. It was an accelerant, but they did not have it as evidence. Um, they did not collect it. They did not collect a plastic bag. They do not have the contents of any bags, etc., etc. No, I disagree. You see me with the gun. I have already shot someone. You're running towards me yelling, and I don't know you, nor do I know what you have on your person. You are a threat to me. I'm fleeing. Hey, Harris is here. I'm gonna have to give this some due diligence. You retracted your message. I didn't see that one. The judge just did a good old boy whistle and set a precedent. Let me see. So as it relates to still we may believe came out of this can only be to Wisconsin, because this is Wisconsin. And it does not have to stay in effect because the voter has the right. They don't like that occurred during this trial. Any law that was not, that was the law, the one about being 18 and under, that one that they threw out, that's an issue. Not being unlawfully having the gun in the first place, that is an issue. But the DA messed that up because they were there with the wrong case law on it. And we covered that over here because when they were arguing back and forth, we started looking at the statutes that they were arguing, and they did not meet the issue at hand. The judge just said, a good old boy, Miss G, you right in a way. The kid tried to flee. They kept rushing toward him, so fleeing is no longer an option. When he threw out the sixth charge and let him pick the jurors from a hat, define how you see picking the jurors from a hat. And people can miss me with that he was a kid stuff. No, I'm not defending him as a kid, but throwing out the sixth charge, which was the unlawful 18. The problem with the law, Carenza, because we went and looked it up, is that the law was not written. It is ambiguous. It needs to be cleaned up. There was no, when you read law, you'll see so and so, if possession of a gun. Let me find the numbers for y'all. Because we did this on a private live. We was like, what the hell? Because we was looking it up and it was just shocking. second. I have the numbers written somewhere. And by the way, it's a good coverage, conversions of files and sending somebody a file and shit. So that was good. Let me just go get my other book. My other book. Okay, here we go. Going to the chapel and we're gonna get married. Where is the he was not there to protest against police press. He was there to be a menace. They didn't prove that. They didn't put up any witness other than the guy that he shot to demonstrate that he was there to be a menace. A part of me thinks that they were prohibited from doing that, but they did not bring that kind of evidence forward. All right, Kyle Rittenhouse, the EMT. I wrote down his testimony. I took notes of his testimony. I swear though it was in this book. Oh, here it is. And I'm gonna highlight them. Hold on again. Wait 1 second. I need to highlight these numbers so the next time I find them easily. Furthermore, when have you ever known a judge allow somebody to select their own jurors? Okay, that selecting of the juror thing. They had 20 jurors. 2 jurors were dismissed somewhere in the case for whatever reason. And then the 18 jurors was left. You only let 12 to decide. So he, according to this judge, his process has always been to allow the defendant to pull out names out of the spin thing. It wasn't a hat. It was one of and that's what he did. He picked out 6 names in there. I didn't see the full coverage of it. I didn't go back. I came in late. I only saw where he was drawing it. So I didn't see how they put the numbers in there. I didn't see how they validated that they put all 18 numbers in there. I didn't see all of that. So I can't speak on all of that. I only saw him pulling out the six numbers. All right, I'm gonna look at 9. So when he was charged and indicted, he was charged and indicted on 948.60. So I'm gonna try to find that again to look to the language of it, because I like to speak in real stuff. So hold on a second. Let me go there. Nugget, you don't belong where you're at. 948.0 Wisconsin Penal Code. All right, possession of a dangerous weapon. And if I recall, the reason why this was thrown out was because this law spoke directly to the type of gun a person had. But I'm gonna share the screen with y'all in a second and we'll look at it together. We'll talk about it together. Do 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 go Momo. We don't need sound for this, so we just gonna share this. Okay, so here we are. Um, so this was what he was charged with at the time of the uh, this is what he was charged with. This is what he was indicted on. 94 948.60. What they were talking about in the conference, charge conference, they were talking about 293.04 and 295.19. But this is what, in essence, they charged him with. In this section, dangerous weapon means any firearm loaded or unloaded, any electric weapon as defined in 941.295. Then it's talking about metallic knuckles or knuckles of any substance which could be put to the same use with the same or similar effect as knuckles. Some fucking the nunchucks or any similar weapon consisting of two sticks of wood, plastic or metal connecting at one end by a length of rope, chain, wire, or leather. So they defined what a dangerous weapon is. So we're going to say that for this one, it would have been a firearm loaded. A loaded firearm would have been a dangerous weapon. Now you see, as you read this law, what you normally will see is they'll tell you what it is if a person violates it. Any person under 18. So we're going to go to section 2. So this would be section 2, subsection 2. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor, except as provided in paragraph C. So C is below this. Any person who intentionally sells, loans, or gives a dangerous weapon to a person under 18 years of age is guilty of a Class I felony. So that's going to be his friend, his sister's ex-boyfriend, who testified. He's got that charge. So he's got that one. Whoever violates, so at best it would have been a Class A misdemeanor. Whoever violates paragraph B, that's the person who sells something to a minor, is guilty of a Class H felony if the person under 18 years of age or under discharges the firearm and the discharge causes death. So that guy who testified, his sister's boyfriend, ex-boyfriend, he's looking at some heavy shit right here, because he's looking at a Class I felony for buying the gun, and he testified that that's what he did. And then so he's actually saying he's guilty of this because all they have to use is the Rittenhouse testimony. And then he's saying that in this paragraph is saying that he's guilty of a Class H felony if the person under 18 years of age discharges the firearm and the discharge causes death to himself, herself, or another. So he actually did discharge the firearm and killed 2 people. So that guy who testified, the first one, I think his last name was Dominic Black, he's looking at some heavy shit right here if they follow through on his case. I'd like to watch that, see what happens. A person under 17 years of age who has violated this subsection. So notice how we go down to D and they start talking about a person under 17 years of age But there's nothing more specific to a person under 18 years of age. Kyle Rittenhouse was 17 years old at the time. So he wasn't under 17 years of age. So whatever this says was not applicable to him. So a person under 17 years of age who has violated this subsection is subject to the provisions of chapter 938 unless jurisdiction is waived under section 938.18, or the person is subject to the jurisdiction of court of criminal jurisdiction under section 938.183. See this language? A person under 17 years of age. Let me just highlight it. I'm on D. This is applicable to a 17-year-old. This is the only thing that's applicable to an 18-year-old. And I guess we just have to look at what a class A misdemeanor is for this state. Let's look at number 3. This section does not apply. So you see this language right here? To a person under 18 years of age. This section does not apply to a person under 18 years of age who possesses or is armed with a dangerous weapon when a dangerous weapon is used for target practice. All right, so this does not apply. Let's see what does apply. Being used as target practice under the supervision of an adult or in the course of instruction in the traditional and proper use of the dangerous weapon under the supervision of an adult. This section does not apply to an adult who transfers a dangerous weapon to a person under 18 years of age for use only in target practice. Next section. This section does not apply to a person under age 18 years of a person under 18 years of age who is a member of the armed forces. So these are all the people who this section does not apply to. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of 941.28 and is not in compliance with 29.304 and 29.593. So these are the sections that they was arguing that he was in violation of. But when you go to these sections, they were specific to like firearm, like being on a range and stuff like that, which was not applicable to this situation. Then they have a stupid section right here. I'm gonna call it a stupid section where they give you the history of how this law became, why this is here, so that you would have the rationale behind this law. And that is what the defense team argued against. And that is why the judge said he threw this out. He threw that law out based on those reasons of it not having to do. Also, oh God, hold on. Wait a second. I gotta go back. I didn't see any of this. Furthermore, when have you ever known a judge to allow somebody to select their own jurors? The judge would not allow the prosecutors to use word victim because they said all he had a hunting rifle. Where was his hunting license at? And he was not at a hunting ground. My daddy was an avid hunter. When he was alive, that was his hobby. Minors in Kenosha, Wisconsin can have hunting rifles. So all the black minors, go get y'all some hunting rifles. However, don't do what he did because we know how it's going to go. Right? His friend is being charged. And also, I think people need to remember that he was pointing that gun at some black boys earlier, and that was their intent. Yes, and these are all points that I made, Carenza, where the prosecutor did not bring forth enough witnesses to speak to Rittenhouse purpose for being at the at being there. And the witnesses that he did put forward, the owners of the establishment, Sal and Sam, they were the worst witnesses ever because they would lead you to believe that they are afraid of something. I think they were afraid of whatever gang Kyle belonged to, that they allowed these people to just commandeer or take over their property, and use it as ground zero for their stakeout of the evening. But nevertheless, there was an overwhelming tolerance for Kyle and his comrades because the police department was even thanking them for their services. So it is very hard to find a juror of his peers, which are people that would be thanking him for his services. That would have found him guilty beyond a reasonable doubt. All they're saying is that there was doubt within reason, and they took that road. But that's all right. We will see young Kyle again in life, because unfortunately he has a big target on his back. And if he has proven that he cannot be a high school student because he is enrolled and graduate from some online class, he does not take orders well. Uh, he's our next nurtured terrorist, and we will see him again down the line. We will see him again in life. I don't buy this innocent creature of nature. So we will see him again. He will lead us to believe that the fallout from being in this case will cause him misery for the rest of his life. But at the end of the day, the jurors have spoken, and this is the system that we got in place right now. And what we need to do is create or generate laws that will not we need to generate laws that work against what we just saw here happen. Look, the cops couldn't handle the riots, the rioters. No, they couldn't. They knew the gun groups were stationed at certain areas, so cops pushed protesters towards that area. That is true. And that was another thing that was definitely presented in the case. So if people want to sue, the family wanted to sue, they could definitely sue because law enforcement put those people in a bad situation. Now, the $10 million dude who was suing for $10 million, the one who lost his bicep in this, he has a lawsuit, but his testimony could have negatively impacted his ability to win his $10 million. Whoever these people have as attorneys, I would have never let him testify. And I would have definitely limited the scope of what he testified to. Um, I don't believe that this is a case where there was a rush to judgment. I just believe this was a case that was not well prepared to go forward. And sometimes you need to measure your damages. At first, I thought all of the efforts to seek, and I'm going to say this is happening in the Aubrey trial as well as in Rittenhouse. You hear these defense attorneys screaming mistrial, mistrial, mistrial all over the place, right? And I think they're doing it more these days because of what happened to um uh what's the dude up there, the police officer that stood with his knee on somebody's neck for a long period of time, him. I know his name, I just don't want to say it because I feel like um we're giving these people too much credence when they just are terrorists, domestic terrorists. um they've been shouting mistrial, mistrial, mistrial all over the place. What this prosecutor did not do in this case, and the judge told him so, told them so. And I thought it was just crazy. You could have filed an appeal. Nothing prevented decisions that I made in the middle of this case. And if that wasn't an admission of I might be wrong and you've done nothing to stop me in being wrong. So the stuff is on you. That's how I saw it at that moment. When the judge said that, I was like, oh, the non-melanated rioters showed up and they could have been handled the way they have handled Black protesters. So for me, that's not an excuse to show up at a protest and start handing out bricks in an organized manner. Again, I'll state I agree. I agree. These professional, that's why I had dubbed this the professional protesters trial, because it was the first time, or in this series of protests that began in 2020, was the first time that I had begun to really understand the damage of the professional protester on the protester who just came out seeking redress, seeking their First Amendment right to assemble. And then you have these people integrated in the protest, and at the end causing problems, making it more difficult to protest. So I see them as a distraction. Nevertheless, I view them as a distraction, and they cause more harm to the purpose of the protest in the first instance. I'm gonna go back and read that book that I keep talking about, and I don't have it on the bookshelf down here, but I will definitely deal with this professional protest world. To show up to protest and start handing out bricks. Yeah, that's just the whole stuff is just crazy. But this is the decision du jour. Um, I'm gonna speak since I have Corinza in the house. Um, I'm looking at this Ahmaud Arbery case, and for weeks now, I've been screaming at the television set when I see Lee Merritt and I see us, um, I see representation from a Black voice on this, and I'm like, why are they doing this? Why are they doing that? Why are they doing this? And then I heard this attorney, God damn it, God damn it. This attorney that the videographer has, because I'm not using his name either. the videographer's attorney has been like one of the worst. So if anybody can ever go to an appeals court and say, I had defective counsel, can be the Roddy Bryan dude. His attorney from the onset thought it was imperative to put the video out into the public space because he thought that once the public saw the video, they would understand that those men were justified in doing what they did. That backfired, caused them all to go to jail, right? And I saw the rope-a-dope. I explained it earlier where I was like, I feel like they're doing a rope-a-dope here, and they're gonna push this all on Roddy and say, listen, his climb to fame with the video, had he not just joined in and started chasing him down with his car and stuff, this man probably would have never attacked me, Travis. Yo, the dude is over the freaking top with his stuff. He's just over the top with it. So so I'm listening to him, and when he's talking about black pastors, and he's like, how many pastors can a black family have? If you're a child of God, everybody's a pastor. When especially prayer don't have no limit, no color restrictions. Like, oh my goodness, it was just like, oh, and it was crazy to me. It was crazy. But then the reaction to have them converge onto the steps. I need people to look at Georgia law and really tell us, is there something about jury manipulation or jury nullification that's written in their statutes? Because I thought the district attorney, who I enjoy her anger, I love her heated angst. She something about this just don't sound right. But she complimented his ego on Friday. Said he's a very intelligent person. She said, I've read his briefs. Look, I haven't done this. Who is this dude? Hold up. Doxers, we're about to dox up here. Kevin, this is how you dox. No, I want to read his bio or whatever. Yo, he is like the biggest fool on this thing. And he's always piggybacking on somebody. Oh boy, the blue eye bandits are out today. Georgia litigator works hard to preserve clients' fundamental rights. Yeah, but I felt like there was a message in her breakdown of him. All right, so he does DUIs and DWIs, divorce, family law, real estate. So he's a little spread out into everything that you could do. You can count on me to wait a second. I gotta show y'all this because you can't make this stuff up. You really can't make this stuff up. So he says, in his criminal stuff, you can count on me to deliver comprehensive defense against any type of criminal law allegation, from traffic tickets to death penalty cases. So we got DUI, divorce, family law, and real estate. All right. So he does a free consultation. Um, this does not give me his background. So hold on. I want to know where he went to school at. I want to know more about him because he is shrewd. We don't have people that come in here to troll, sir. We have something called the lounge, so you can have a seat in the lounge. You can have a seat in the lounge. That's what we do. Um, okay. I'm sorry, y'all didn't get to see that. Somebody came in being rude, so I escorted them to the lounge. Maybe the next time. Um, do 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 do. Let me just look and see if I find anything else on this dude before I go, because he's gonna be my project today. Because I just want to know more about him. Um, so it says University of Georgia School of Law. So he's just been hanging out down there. Um, who are these people? Okay, so he's just been hanging out. College of William and Mary is where he went for his undergrad. College of William and Mary. All right. Anyway, just some places I would never go. Anywho's, that's where we are at. Anyway, I'm gonna go skedaddle, try to get my Saturday up and started. I was getting a lot of reach out. I got some people I have to reach back out about a few things. So I'll be back tomorrow for worship. Let me just put a claimer on that. The common theme from both trials is a violation of um the common theme on both of these trials or all of these trials when white people take the life of um others is they feel they have an inalienable right to do so. So what we learned from the Rittenhouse case is that it doesn't matter if they take the life of a white person or a black person. White folks believe that they have a right to do what it is they do. And it doesn't matter who they do it to. And that's the bottom line to all of this. So um, they do it to their own as well. Um, that's what Rittenhouse has shown. I am surprised that the Jewish community has not whipped out, and I'm surprised they have not rallied harder in the Rittenhouse case. But I think it's because I'm gonna leave it like that. When people, when you gotta have a squeaky clean lifestyle for some people to even want to advocate for you and them. Don't make one bad mistake. But I'm gonna just say, for me, looking at Rittenhouse, I see where he's already had a rough childhood. So it's, again, we will see him again in life. We will see him again. This is not no learning point for him. Based on his arrogance that he showed and the way it was pampered and nurtured throughout this trial, with the judge's actions and his attorney's actions and the hugs and the, it was crazy. It was crazy watching the privilege in full effect. Brian attorney, that his constitutional rights is being violated because he's got to sit in a prison cell without window. Yo, hold up, wait a minute. That's why I said this Garth guy is amazing to me, because here he is in a criminal trial with the full assumption that his client is going to get off, making a record of cruel and unusual punishment, which is the absolute inverse of what is supposed to happen when you are awaiting trial. See, the reason why they have bail for the purpose of just securing, it's a surety, S-E-S-U-R-E-T-Y. It's a surety that the person will return to court for their case. And that's the only reason why they're supposed to be bail in the first place. And here these men are being incarcerated, and basically staying in jail during this whole period of time. So he's just setting up his damages. He's setting up his damages, and they're probably going to counter sue if they are freed, right? If they are found not guilty. He's probably going to sue the Ahmaud Arbery family and Edgar, the counsel to Ahmaud Arbery, and all these Black pastors, et cetera. So I can see him making that case, and he's probably going to sue them for damages for his client pain and suffrage of this trial. And there's going to be more to come if there's not a guilty verdict, if he's found not guilty. I could see that. And he set up the precedent in this case, because he's already making a record of it that he's going to refer back to. Because I was like, why are we asking this dude this stuff? And it's just crazy. People are sitting in jail today who are awaiting trial that have been, and not only don't they have this dude said he got 3 meals a day. I can assure you that in the prison system there is not 3 meals a day going on in the prison. There's perhaps 2 meals a day, and if you're lucky, one of those meals might be a hot meal. So and they going to turn right back around and countersue them. So they're suing the city, right? Ahmaud's people are suing the city, and these people are going to sue them for defamation if they could get some stuff going about what's his name's language. I'm not saying, so don't get me wrong, sometimes when I say things, I just give in the flip side of it, because I'm trying to cover the cases from a 360 degree a full circle all the way around. I'm not just trying to cover it from my deepest feelings, but from all perspectives to show it. I will sue every last one of them who murdered Ahmaud for emotional distress and wrongful death. Well, she definitely could sue for wrongful death. There hasn't been anything proven. The thing about these two trials, Rittenhouse and now Ahmaud McMichaels, because I'm not going to call it Ahmaud because he's not on trial. This is just his death. So the McMichaels and Rittenhouse is that the burden, once they do an affirmative defense to murder, it is self-defense. The burden becomes that much more harder on the prosecutor to prove that the prosecutor is no longer proving that the person killed this person. The person's agreeing, yes, I killed him because it was self-defense. They are now trying to prove beyond a reasonable doubt that it wasn't self-defense. That is harder to prove than beyond a reasonable doubt someone killed somebody. Self-defense, proving against self-defense is harder for the DA to achieve. And in the high profile cases, we're running the risk of not being able to prevail. We're not getting people and saying, yeah, that person did not have a right to self-defense. We're losing in those conversations. I guarantee you they're going to psychologists and getting some type of therapeutic counsel. That's just my opinion. Well, I believe I believe the whole shebang. Actually, we just watching this stuff, we should go to therapy and sue for duress because this stuff is stressful even watching it. And it's stressful being a mother to a Black man. It is stressful. All of this stuff is just stressful, period. I'm gonna leave it at that. Corinza, thank you for dropping in. I've been catching you in the nighttime because you come on late and I'll be like one eye open and the other one. But I always love your energy when it comes down to this to these type of cases. And that's, yeah, we should be suing for the rest of this stuff, how it's being covered by media or not covered. But we'll see what we'll see what comes out of it. Thank you everyone for stopping through. Still Cross, Carla, Miss G for stopping in today. I appreciate it. Hey, Fire Complex. I'm more than a pretty face. Next time, come in here and stick to the topic, buddy. This is Mo. I've got to go.